Right. I left off on page 53 of the Convisor mini review, this bar material, and really just skipped over the covenants of general warranty deed, cession, the grantor covenants that he has the estate she purports to convey. She must have both title and possession at the time of the grant. Covenant of right to convey, the grantor covenants that she has authority to make the grant. Title alone will satisfy this covenant. Covenant against encumbrances, the grantor covenants against the existence of physical, example, encroachments, or title, example, mortgages, encumbrances. Covenant for quiet enjoyment, the grantor covenants that the grantee will not be disturbed in possession by a third party's lawful claim of title. Covenant of warranty, the grantor agrees to defend against reasonable claims of title by a third party and to compensate the grantee for any loss sustained by the claim of superior title. And covenant of further assurances, the grantor promises to perform acts reasonably necessary to perfect title conveyed. Breach of covenants, 3 of the covenants, cession, right to convey, and against encumbrances are breached, if at all, at the time of the conveyance. Quiet enjoyment, warranty, and further assurances are future covenants and are breached only upon disturbance of the grantee's possession. Present covenants cannot be enforced by remote grantees, but future covenants run with the grantee's estate. Damages and remote grantees. If there are successive conveyances by general warranty deed and the last grantee is evicted by lawful claim of title, he may sue anyone up the line. Some states allow him to recover to the extent of consideration received by a defendant covenantor. Other states limit recovery to the lesser of what he paid or what the defendant covenantor received. Statutory special warranty deed. In many states, the use of the word grant in a deed creates by implication 2 limited assurances against acts of the grantor, not her predecessors. 1, that the grantor has not conveyed the same estate or any interest therein to anyone other than the grantee, and 2, that the estate is free from encumbrances made by the grantor. In quitclaim deeds, releases whatever interest the grantor has. No covenants of title are included or implied. Estoppel by deed, if the grantor purports to convey an estate and property that she does not then own, her subsequent acquisition of the estate will automatically inure to the benefit of the grantee. This doctrine applies where the conveyance was by warranty deed or where the deed purported to convey a particular estate. It is not usually applicable to quitclaim deeds. Rights of subsequent purchasers. Most courts hold that title inures to the benefit of the grantee only as against the grantor. Thus, if the grantor transfers her after acquired title to a bona fide purchaser for value, the bona fide purchaser will prevail over the original grantee. Remedies of grantee. The original grantee can accept title or sue for damages for breach of covenant. Now, recording at common law, this is just a brand new section. At common law, if the grantor conveyed the same property twice, the grantee first in time generally prevailed. The recording acts change that outcome under certain circumstances. There's notice statutes. Under the notice statute, a subsequent buyer for subsequent bona fide purchaser, person who pays value and has notice of the prior instrument, prevails over a prior guarantee who failed to record. The key is that the subsequent purchaser had no actual or constructive notice at the time of the conveyance. In a race notice statute, under the race notice statute, the subsequent bona fide purchaser is protected only if she takes without notice and records before the prior grantee. And lastly, race statutes. Under a pure race statute, Whoever records first wins. Notice is irrelevant. Very few states have such statutes. So I have a graph on page 55. Also have a graph from the professor. So I'm going to compare the two graphs to decide which one goes on the wall. But let's see how alike they are. His is colorful. It's got race in one column, notice in the next column, race notice in the last column. It's got X's to indicate, to enumerate when a bona fide purchaser is required, which is all of them. Without notice is a requirement, and that happens to be a requirement for notice and race notice jurisdictions, but obviously not for just a pure race statute. And then record first wins the race, and that is enumerated in the race statute and the race notice statute. I have two kind of caveats, one to race, one to notice. So this one was just a question. These are questions about defective deeds. Do they give constructive notice? If it's patent defect, no. If it's a latent defect, yes. But I would ignore that because it's in my own handwriting. And to be honest, I feel like if there's a deed recorded, you have notice that something's up. If it's not in the chain of title, that's a different story. And you can see how important that is because I haven't reached it yet after talking about deeds. So, and I don't intend actually to go much further into this. Oh, here's a title search. Maybe I will go into the title section. So let's read the chart that Barbara gives us. This is rows, right? So notice is a row, race is a row, race notice is a row. The typical language is given and the effect is in the third column. So for the typical language that I've been seeing in these MBE questions, no conveyance or mortgage of an interest in land is valid against any subsequent purchaser for value without notice thereof, unless it is recorded. That's your notice statute. So no conveyance or mortgage of an interest in land is valid against any subsequent purchaser for value without notice thereof, unless it is recorded. The effect is that the subsequent bona fide purchaser for value without notice prevails. In a race statute, it's like the complete opposite, because the effect will be that the grantee who records first prevails. So the typical language to tell you that it's a race statute is no conveyance or mortgage of an interest in land is valid against any subsequent purchaser whose conveyance is first recorded. No conveyance or mortgage of an interest in land is valid against any subsequent purchaser whose conveyance is first recorded. It says nothing at all about notice. And then lastly is the race notice. No conveyance or mortgage of an interest in land is valid against any subsequent purchaser for value without notice thereof, whose conveyance is first recorded. The effect of this, basically combination of the two, is subsequent bona fide purchaser for value without notice who records first prevails. I don't think I've ever been asked an MBE question where they didn't talk about notice. So as much as I'd like to say, oh, good, if it doesn't say anything about notice, it's a race statute. But I've been so lucky as to get an MBE question that doesn't talk about notice. So I've had either notice statutes or race notice statutes questioned so far in my preparation. Moving on, I see here the shelter rule, which is a purchaser. I think it's over the course of discussing bona fide purchasers. Mortgagees for value are purchasers. Donees, heirs, and devisees are not protected because they do not give value. A purchaser from a donee, heir, or devisee of the record owner is protected against prior unrecorded conveyances of the record owner. I have written here shelter rule, so that must be it. Now, judgment creditors, most states permit a plaintiff who obtains a money judgment to place a judgment lien on the defendant's real property by filing the judgment in the appropriate county office. The majority, however, hold that such a judgment creditor is not protected by the recording statute against a prior unrecorded conveyance by a defendant. This is actually the shelter rule here. It says transferees from a bona fide purchaser. A person who takes from a bona fide purchaser will prevail against any interest the transferor bona fide purchaser would have prevailed against. This is true even if the transferee had notice of a prior unrecorded mortgage. This rule does not, however, help the transferee who previously held title. She cannot ship through a bona fide purchaser to get good title. Purchaser under installment loan contract. Most states, a purchaser under an installment loan contract is protected only to the extent of payment made. In a dispute with a prior claimant, the court may award the purchaser 1, the share of property as a tenant in common equal to in proportion of the payments made, 2, a lien on the property to the extent of the amount paid, or 3, the entire property subject to a lien on the property to the extent of the balance owed. Without notice is defined here. And just remember, actual constructive record or inquiry notice is enough to meet notice. Chain of title record notice. A subsequent purchaser will be held to have record notice only if the deed in question is recorded in the chain of title, which means that it is recorded in such a manner that the searcher would reasonably find it. Although no one has a legal duty to perform a title search, a subsequent purchaser will be charged with the notice that such a search would provide whether or not she actually searches. Wild deeds is a record deed that is not connected to the chain of title. It does not impart constructive notice because a subsequent purchaser could not feasibly find it. Deeds recorded late. Deeds recorded before grantor obtained title. Not in the chain of title, most courts say. The minority view protects the prior grantee over the bona fide purchaser on an estoppel by deed theory. The fourth part here in this chain of title section is a deed in chain referring to instrument outside chain. Reference to another instrument and recorded document that is in the chain of title may impart constructive notice of the instrument referred to, even if it is unrecorded or not itself in the chain of title. Restrictive covenants, deeds from grantor. I think at this point we're kind of talking about covenants and easements. Inquiry notice. What an inquiry would have revealed is what you will be charged with. Generally, this is like if you've got a tenant on the property you just purchased. You want to bring that up with a seller and understand why there's someone there. Maybe they actually own it. Ask them. Title search. In a tract index jurisdiction, the searcher looks at the page indexed by block and or lot describing the property and any instruments affecting it. In a grantor-grantee index describing the property and any instruments affecting it. Jurisdiction, a searcher establishes a chain of title by searching back in time in the grantor index. From that point, he then searches forward in time in the grantor index to see if the grantor conveyed an interest to someone outside of the backward chain. So you go backwards and forwards in a grantor-grantee index, whereas a tract index is a little bit more easy. Sometimes recorders make mistakes. The effective recording unacknowledged instrument. It says the better view is that it imparts constructive notice. Conveyance by will. I wanted to skip this section because I read wills. We talked about redemption. This is when the property is sold, right? Exoneration. There's a doctrine requiring the will to expressly provide for payoff. Lapse and anti-lapse. We know what that means. A lapse and beneficiary dies before the testator. Abatement is if the state assets are not sufficient to pay everything, all the grants in the will. And security interest in real estate, you have a mortgage. There's 6 types. The mortgage, the deed of trust, the installment land contract, an absolute deed, a sale lease back, and an equitable vendor's lien. One thing about installment land contracts is that they can have forfeiture clauses allowing the vendor upon default to cancel the contract, retake possession, and retain all money paid. Those are common and generally enforceable. An absolute deed, if given for security purposes, can be treated by the court as an equitable mortgage. To be treated as any other mortgage, for example, a creditor must foreclose by judicial action. A sale leaseback is when the landowner may sell her property for cash and then lease it back from the purchaser for a long period of time, like an absolute deed. This may be treated as a disguised mortgage. Equitable vendor's lien arises by implication of law when a seller transfers title to the buyer and the purchase price or a portion thereof remains unpaid. That's all about. Transfers by mortgagee and mortgagor. This is crazy. I haven't seen a single MBE question on this. As much as it's relevant to my banking career, I'm just reading it to myself. But it's saying the note and mortgage must pass to the same person for the transfer to be complete. But it says that after saying that all parties to a mortgage or deed of trust may transfer their interests. But for the transfer to be complete, the note and mortgage must pass to the same person. Transfers by mortgagee, transfer by note without, transfer of mortgage without note. So you can compel the note is sent. Transfer of note without mortgage. The note can be transferred without the mortgage, but the mortgage will automatically follow the properly transferred note. The mortgage transfer expressly reserves the rights to the mortgage. No separate written assignment of the mortgage is necessary. Methods of transferring the note. The note may be transferred either by endorsing it and delivering it to the transferee, or by a separate document of assignment. Only if the endorsement and delivery method is used can the transferee become a holder in due course. To be a holder in due course of the note, the following requirements must be met. The note must be negotiable in form, payable to bearer or to the order of the named payee, with a promise to pay a sum certain and no other promises. The original note must be endorsed and signed by the named payee. The original note must be delivered to the transferee. The transferee must take the note in good faith, no notice that it is overdue, has been dishonored, is subject to any defense by the maker, and must pay value for it. Second, transferring the note without the mortgage, right? The method, I just explained the 4-part method. The benefits of holder in due course status. Takes the note free of any personal defenses of the maker, which might be failure, consideration, fraud in the inducement, waiver, estoppel, and payment. But it's also subject to real defenses such as infancy, other incapacity, duress, illegality, fraud in the execution, forgery, discharge, and insolvency, and any other insolvency. Payment to original mortgagee after transfer of note. If the original mortgagee transfers possession of a negotiable instrument, any payment by the mortgagor to that mortgagee will not count. The holder can still demand payment even if the mortgagor lacked notice of the transfer. However, if the original mortgagee transfers possession of a non-negotiable note, the mortgagor's payment to him is effective against the transferee until the mortgagor receives notice of the transfer. Transfer by mortgagor. Grantee takes subject to mortgage. A grantee of mortgage property takes subject to the mortgage. Assumption. If the grantee signs an assumption agreement, he becomes primarily liable to the lender, while the original mortgagor is secondarily liable as a surety. However, the mortgagee may opt to sue either the grantee or the original mortgagor on the debt. If no assumption agreement is signed, the grantee is not personally liable on the loan. And the original mortgagor remains primarily and secondarily liable. Nonetheless, if the grantee does not pay, the loan may be foreclosed, wiping out the grantee's investment. Due on sale clauses, which appear in most modern mortgages, allow lenders to demand full payment of the loan if the mortgagor transfers any interest in the property without the lender's consent. Defenses and discharge of the mortgage. Defenses to underlying obligation, failure of consideration, duress, mistake, fraud, consumer protection, can be defenses to foreclosure, such as understandable, unfair, deceptive, abusive, ability to repay, good faith, effort to mitigate, modify, understand all of that. Discharge of mortgage. A mortgagee's right to foreclose is precluded by a discharge of the mortgage, payment of the debt secured, merger of legal and equitable interest, or the mortgagee's acceptance of a deed in lieu of foreclosure tendered by the mortgagor. So they can just give you the keys. That's what the deed in lieu. The bank, that is. And then the bank holds the property and the loan is discharged. Possession before disclosure. Here's where we start talking about redemption in equity. I will put this on the wall. We made it actually fairly far because we're on page 65. I understand redemptions. I even understand this subordination, in the priority section. I understand the acceleration clause and the redemption. There's two. There's redemption in equity. There's a statutory redemption. So generally it's 6 months after the foreclosure sale. In equity, however, you can only redeem according to the acceleration clause, which is usually just paying the balance of the note of the mortgage. Cannot be waived in the mortgage itself. Now, priorities, this, as much as I understand it, I might be reading it anyway because the way that the MBE questions it is, it uses it as questions is like literally absurd. I don't know who does business that way. So it's like the developers selling land. The purchaser gives them $100,000, gives them $100,000 from their employer loan, and actually takes the loan for the balance from the developer. And then there's a judgment. And then the employer forecloses. Who's paid first? Like, what? I don't know who does business that way, so I can't answer it from my experience. So I'm gonna just read this. It's not that gonna be that bad. Priorities. A mortgage's priority is usually determined by the time it was placed on the property. Foreclosure does not destroy any interest senior to the interest being foreclosed. Foreclosure does not destroy any interest senior to the interest being foreclosed. It destroys all junior interests, but failure to include a junior interest holder in a foreclosure action results in preservation of that party's interest. Modification of priority. Although priority among mortgages is generally determined by chronology, this priority may be changed by the operation of the recording statute if a prior mortgagee fails to record. 2, a subordination agreement between the senior and junior mortgagee. 3, a purchase money mortgage. 4, a modification of a senior mortgage. In parentheses, it says junior mortgage has priority over the modification. 5th, the granting of optional future advances by a mortgagee with notice of junior lien. The junior lien then has priority over these advances. And lastly, subrogation. A senior mortgage is refinanced with the new mortgage. Purchase money mortgages is defined. I didn't think it would be difficult until this whole MBA I just described. Where they're talking about a completely unrelated loan and then the developer gave the guy a loan. So now I feel like confused. A purchase money mortgage is a mortgage given in exchange for funds used to purchase the property. That's what I assumed it to be. PMMs are given either to the seller as part of a purchase price or to a third-party lender. PMMs have priority over mortgages, liens, and other claims against the mortgagor that arise prior to the mortgagor's acquisition of title. How? Prior? However, subsequent mortgages or liens may defeat PMM priority by operation of the recording acts. As between 2 PMMs, the seller's mortgage generally has priority over the third parties. Okay. So the seller's mortgage has priority over the third parties. If there are 2 third-party PMMs, priority is determined by chronological order. Usually 2 PMMs have notice of the other's existence, thus the recording acts are of no use in determining priority. Proceeds of sale. Proceeds are applied. First, the expenses of the sale, then the attorney's fees, then the court costs, then the principal and accrued interest on the foreclosed loan, next to any other junior interest in the order of their priority, and finally the mortgagor. So where does the purchase money mortgage go? I mean, we're just like assuming that they're the one that foreclosed. But it says right here, foreclosure does not destroy any interest senior to the interest being foreclosed. So if it's not the senior mortgage that's ordered foreclosure and it's a junior mortgage who has, and it says further failure to include a junior, it generally, you need to enjoin all these people, I think. You need to give them notice. And this is where I get really confused. Deficiency judgments. If the proceeds are insufficient to satisfy the mortgage debt, the mortgagee retains a personal cause of action against the mortgagor for a deficiency. Got it. Marshalling. This is the last section or part of this section. So nothing has cleared up my misunderstanding. When a property is being foreclosed upon by a mortgagee whose mortgage interest covers multiple parcels, the holder of the subordinate mortgage interest may ask the court for a court to marshal assets. This order forces the foreclosing mortgagee to first foreclose on parcels that have no subordinate security interest and to foreclose on parcels that do have subordinate interest. Only in foreclosing on those without subordinate interest fails to satisfy that debt owed. As among parcels on which subordinate interests exist, those with subordinate interests created more recently are foreclosed upon first. Marshalling does not affect the order of priority of mortgages, but it sounds an awful lot like it does. So this is page 66. Just have to come back to it someday. Installment land contracts. Many installment contracts provide for forfeiture rather than foreclosure as the vendor's remedy for default, but courts use the following theories to avoid that harsh result: equity of redemption, restitution, treat as a mortgage, waiver, and election of remedies. So this is your typical lease to purchase arrangement. And we haven't really been tested on it, but you can see how very much they'd rather not have you forfeit it. So use any and all, whether it's redemption, restitution, treating it as a mortgage waiver, such as if the vendor, the owner, landlord has been accepting late payments rather than, enforcing an acceleration, you might just say that they've acquiesced to whatever has been going on. And election of remedies, damages specific performance, and forego others. Rights incidental to ownership and land are natural resources. There's lateral support, a right to have land supported in its natural state by adjoining lands, for example. Supported land in natural state, if landowner is strictly liable if the excavation causes adjacent land to subside. If it does so where there's a building, the landowner is strictly liable again. Only if it is shown that the land would have collapsed in its natural state. Otherwise, he's liable for such damage only if his excavation was done negligently. Subjacent support: an underground occupant of land, i.e. a mining company, must support the surface and buildings existing on the date the subjacent estate was created. Liability for subsequently erected buildings requires negligence. Water rights for water courses, there's a riparian doctrine and the prior appropriation doctrine. A boundary line can also be affected by accretion and avulsion. I read about them earlier, just because the words were new to me. Riparian owners can use water only in connection with the riparian parcel. Natural flow theory: and reasonable use theory, and natural versus artificial use. Natural flow, reasonable use, natural versus artificial. Prior appropriation doctrine. Individuals acquire rights by actual use. Appropriative rights are determined by priority of beneficial use. If there is a decrease in flow, priority is accorded in terms of time of appropriation, and appropriative right can be lost by abandonment. Groundwater is percolating water. There's like 5 approaches: absolute ownership doctrine, reasonable use doctrine, correlative rights doctrine, appropriative rights doctrine, and a restatement approach. Surface waters is by the natural flow theory, common enemy theory, and reasonable use theory. A landowner can capture by dam or in barrels as much surface water as he wishes. And right to airspace, not exclusive. Owner is entitled to freedom from excessive noise. Right to exclude, remedies of possessor. The possessor of real property has the right to exclude others. His remedies for invasions include actions for trespass, land invaded by tangible physical object, private nuisance, land invaded by intangibles such as odors or noise, continuing trespass, land repeatedly invaded by trespasser, and ejectment or unlawful detainer. To remove a trespasser or tenant, this action can be joined with a demand for money damages. So that just talks about the remedies. It doesn't talk about like what are those things. I already read about zoning in the prior, so I'm going to quickly end on cooperatives, condominiums, and cooperatives. In a cooperative title, the land and buildings is held by a corporation that leases individual apartments to its shareholders because of their economic interdependence and because the individual owners are regarded as tenants. A direct restraint on alienation of an individual interest is valid. Condos, it's got each owner owns the interior of his individual unit plus an undivided interest of the exterior and common areas. Treated as fee ownership, the ordinary rules against restraints on alienation apply. Homeowners association, sometimes called a condominium association, oversees the common elements of the condominium property. The common elements include the exterior of the building, common staircases, landscaping, front gate. The association usually is a legal entity such as a corporation or LLC. There's memberships and fees and special assessments, and the association rules passed by charters and bylaws that place requirements and restrictions on the owner's use of their property. These rules are binding on the members, may be enforced either by individual members of the association themselves. Oh, I'm running out of battery to talk about really much more about anything. But it covered really the whole of what has to be covered for this subject area. Again.